It's 6:35 and a half here on Sky 99.5 FM, and we continue to look at some of the big stories making the news today. Apart from the situation with the Simmons versus Ho revenge porn case, also as a big headline, death threats for accused child abuser. And another big headline, 2 men charged in Tobago double murder. And to help us wade through some of the legal issues involved in these big stories is a senior attorney at law as well as member of the Police Service Commission, Martin George. Good morning to you, Martin George.
Hi, good morning to you, Jessie. And
good morning,
Mr. Good morning,
George.
Edison, and good morning, Dr. Wayne.
Morning, sir.
So, pick a case that you'd like to start with, because they all seem to be landmark happenings, I think, Martin George.
I think the interesting aspect of the Lendl Simmons matter is the ruling of Justice Sipasad, and not just the ruling, but also the comments that he made in relation to, the fact that our laws need to be updated to keep pace with the reality. It is a fact, Jessie May and your panel, that we have seen an explosion, and that's the only word I can use, an explosion in the comments, statements, and information, pictures, videos, everything that is posted online and disseminated, across the internet. And I think persons are very careless, reckless, and they have absolutely no concern for who they may damage or, harm with what they say and what they post online. And I think really we need as a nation to be aware that there are consequences that can follow from such actions, And the thing is, we did have some time back I think that the first major case of, cyberspace defamation, which was the matter involving Mr. Emil Elias and his company, NH International, versus Eugene Reynald. I think Mr. Reynald was a serial cyber blogger who, repeatedly made statements, and some of the statements that were posted online, Mr. Elias and his company, they found that they were defamatory, and as a result, they filed this action, and the court ruled in their favor and held that, look, even over the internet, the things you post and the things you say can be defamatory, and they made an award of damages against Mr. Reynald in that case.
Mr. George, I'm puzzled by the comments that the judge made, that he said the case that this Lendl Simmons case and the Ho girl, that is not covered in any local legislation. So if there's no law against certain behaviors, there could be no breach. Would that be correct?
No, not necessarily. The point is there may be no criminal law covering it. There may be no criminal law, but the point is, if you're talking about a tort or a civil wrong, then you may be able to resort to your basic common law, which would cover your basic torts that are civil wrongs. So therefore, you may be able to fit it under one of the categories of a basic civil wrong, even though you may not have a statutory criminal, wrong that is on the law books. So I think maybe that might be the distinction that we can make there.
Martin George, as you raise the issue of social media, I just want to look at the other big case that's flagged this morning, and that has to do with the child abuse video involving the couple with a giant-sized man physically abusing a tiny tot.
Well,
that case,
there we saw a positive use of social media.
Yes.
To highlight something that was definitely wrong and to be able to flush out the offender. So that's a good way that social media can assist the authority.
The thing is, though, the gentleman in the case is saying that his life is in danger. He's been receiving death threats. I believe he may have been attacked or threatened when he went to court yesterday. And can his attorneys make a case that, his matter has been prejudiced because of the extensive coverage in media and social media?
No, the thing is, as I explained, when the issue came up with Mr. Jack Warner, when he raised the question of prejudice and bias, and in relation to his extradition proceedings before the magistrate's court, when you consider the question of pretrial publicity, and you want to say that there's negative pretrial publicity, you have to consider it in relation to the arbiter or decision maker. So, in other words, at this stage, with a matter that is going to go before the magistrate, then it's whether the actual sitting magistrate is going to be prejudiced by these things. And you have to show that this person is going to be negatively affected. And unless you can do that, the question of pretrial publicity, negative pretrial publicity, doesn't even arise. And I think that's the difficulty, because when we recall the matters of Ishwar Galbaransing and Steve Ferguson in their extradition proceedings, they also tried to raise the issue of pretrial publicity and say that, that it was negative against them. And the courts dismissed their applications because it was held that they could not show that the particular magistrate hearing the matters was actually going to be biased against them by the, negative comments and statements. Remember, a magistrate is a trained person. A magistrate carries out a statutory function, and they would know to guard themselves against the statements that people are making out there, and they would know sufficiently to ignore them. Even in court, sometimes attorneys make statements that magistrates know they just have to ignore, because you're a trained judicial officer. So unless you can show that there is an actual risk of the bias, then you will not succeed in a claim for negative pretrial publicity.
Mr. George, excuse me, the abusing of a toddler carries a sentence of what?
It depends on which section of the legislation they actually charged him under. I am not privy yet to the actual charges.
But it looks as though this might be another landmark element, because he's being charged under the Children's Act, I believe.
That's correct. So I think that's one good thing, in that we are using the laws which have been on the books for some time. It's just that we have not been implementing or enforcing them. Even when you look at the question of the Children's Authority, which was legislation that was actually passed since the year 2000, and we need to understand and remember that, and we were in the year 2015, you saw that in the newspapers, Miss Stephanie Daly, senior counsel, who is the head of that authority, she has lamented the fact that, look, there are several aspects of the law which have not been implemented in terms of physical infrastructure, in terms of the, you're supposed to have the safe houses, you're supposed to have the halfway houses, you're supposed to be able to certify these homes and nurseries and, places of care, and that has not been put into place. So the thing is, we need to understand that as a nation, we must move beyond the talk and the rhetoric and actually implement many of the laws that we actually have on the books.
I'm looking at the timeline, Mr. George, of the Lendl Simmons case, and the whole thing started when the Miss Ho decided the affair had finished and so on. Of course, we're not trying the case again here. That she sent the photographs to Mr. Lendl Simmons's girlfriend, as the case might be, and then it was tit for tat and so on. So even though, again, coming back to what's on the law books and so on, could a judge use his personal outrage to craft laws in a way on the hoof?
Well, I don't think it's a matter of crafting laws. We have to we have to be careful in terms of how we describe it. I think it's a matter of using the framework of the existing civil wrong or tort, and you are saying that, look, this may fit into the category. But again, on the issue that you started off mentioning about trying the case again, I actually think this is a matter which we ought to have the input of the Court of Appeal, because it's so important.
Yes.
I mean, I don't know what Mr. Simmons and his legal team plan to do, but I think it would be very interesting if this matter were to go to the Court of Appeal to hear their take on it, because there are several aspects, I think, that need some further elucidation and clarification. Because first of all, how do you measure the quantum of damages to award in such a circumstance, especially if there's little or no precedent locally to guide you? So you ask yourself, how do you come up with a figure of 150,000? Then, of course, I don't know what was the defense that was used, because I haven't seen the papers that were filed. But unless it is a case where Mr. Simmons admitted in his defense that he actually disseminated this material, I would have thought that the first thing you would do if you are defending this matter, you challenge the fact of the dissemination. Because when we look at the email gate case, where despite repeated requests by the police authorities, the central authority, the request from the Attorney General's office, it appears that we cannot get from Google definite confirmation as to simple sending of an email, from various public figures, as alleged, So if it is that cannot yet be conclusively determined, at least according to what the police service has been able to tell us, then I wonder, how was it proven that Mr. Simmons was the sender of this information that is alleged, to be containing this, the photographs which were offensive to the young lady. So, and then when you consider that she herself appears to have admitted to sending and disseminating the same photograph, then I think it raises serious technical and, questions which I think from an evidentiary point of view, I would have had a field day if I were defending this matter in terms of, disputing the question of your proof. How do you prove that it was me who sent this? And I would go to the question of, can you prove over which engine, which internet service provider this was carried? I would have gotten very, very technical in terms of my defense. So as I say, I don't know what was the basis upon which they defended the matter, but I think it's the type of scenario which I would love to have the Court of Appeal weigh in on it and hear their take on these issues.
In his summary, Justice Prasad said the court believes it cannot confine itself to a myopic view of the law. In the absence of legislative protection, the common law concept of breach of confidence has to be molded so as to address modern societal demands. So he's taking, he's interpreting what currently exists and molding it to fit the situation.
And you use the common law in that regard. But here's the next question that I would raise. I mean, even if I were defending this matter or even if I were appealing it, the question I would raise is, okay, if you're talking about a breach of confidence, if she is the person who first sent out the pictures, then which confidence am I breaching if I resend them? If you understand me, because you are disseminating it over the World Wide Web, over the internet. The point is, there's a possibility of that being intercepted. You have hackers who could always get into your system, who could, steal your information. So if you are sending it out in the first place, then as far as I'm concerned, you are not concerned about your confidentiality. So don't tell me if I pass that on that I am breaching your confidence. So I think it's really an interesting matter. And, I love these exciting areas of the law because this is how the law grows and develops. And I think it was very, a very strong judgment by Justice Prasad. And I think he took a very, a very strong stance. And I like that because at the end of the day, you have to make decisions one way or the other. And then, of course, you always have the Court of Appeal where the decision can be tested further. You have the Privy Council where you could test it even further. So I would love to see this explored, a bit more in the legal system.
With regard to the legislation, if I remember correctly, the cybercrime legislation that was laid in the previous parliament, the 10th parliament, would have dealt with some elements of this. And we have an assertion from the acting Attorney General, Stuart Young, that they will be putting the cybercrime bill back on the docket for this parliamentary term.
Okay, well, it would be interesting to see the debate in relation to that, because I'm sure that we would hear from both sides of Parliament the pros and cons of various aspects of the legislation. Because at the end of the day, we also have to understand that, look, while there is a need to police these matters, there's also a practical side to it, because our police service certainly cannot run down and try to prosecute when you think of the thousands and hundreds of thousands of things that are posted online every day, I can't say our police service really, seeking to prosecute all possible offences in that regard.
Mr. George, I was just wondering, couldn't the Justice Frank C. Prasad include in his ruling an apology from Mr. Simmons to Ms. Ho?
Well, the thing is, in circumstances such as this, I would imagine an apology is something that has to come voluntarily, because in other words, if I am not genuinely contrite, then there's no point in ordering me to apologize. Someone may say the words, but the point is, if there's no genuine feeling behind it, then it really is of little or no value. So what you have, like for instance, in defamation matters, an apology is sometimes offered voluntarily by the defendant if they know for sure they're wrong and they admit to being wrong, and they do that by way of mitigation. So that goes towards mitigation of damages. So then when a court looks at the matter, the court can say, well, okay, yes, they were wrong to do this or say this. However, at least they admitted their wrongdoing and they have offered an apology. So therefore, I will not punish them as severely in terms of an award of damages. So it's really something that has to come voluntarily.
In terms of the images themselves, the ones that were presented in court, they are to be destroyed. And I think both sides may have been ordered not to distribute any further copies of the material.
Yes, but you see, again, I have very serious issues with this whole matter, as I say, from an evidential point of view and from the question of the breach of confidence. And, I'm really curious to see how this will play out further if it is that they do take it to the Court of Appeal.
Martin George, we're going to leave it there for now, but thank you for joining us this morning on the Breakfast Roundtable.
It's a pleasure as always, and good morning to you and your panel.
Thank you,
Mr.
George.
Trinidad and Tobago.
Martin George, a senior attorney at law and also member of the Police Service Commission, weighing in on some landmark cases in the courts. We want to say thanks to Republic Bank Limited for making our news updates in this hour possible.
The Bank of Chiching, the Bank of Writing.